Yes.
Item number 35 due to my personal difficulty, my lord.
Just a minute. Just a minute. Just a minute. There's some problem. Mention the list. Why दोनों वही कर? कैसे चेक? Meeting code डालो मैं. Permanent meeting code. Just a minute. I'm joining in the mentioning code. There are some people out of list mentioning. I'll be joining later on over here. Good morning.
May I mention, my lord, from the list?
Item number 35, my lord. Due to my personal difficulty, I am praying for adjournment, my lord. I have taken consent from Mr. Indrajit Sinha, my lord.
You have taken consent?
My lord. Let it be after 2 weeks, my lord. 35.
Take down. Mr. Advocate Muhammad Jalisur Rahman, learned advocate Mr. Muhammad Jalisur Rahman submits that this case, prays to adjourn this case on ground of his personal difficulty. He submits that he has already taken prior consent from the Council of the Appellants. Full stop. Next para, considering his submission, this case is adjourned for 2 weeks.
My lord.
There is no stay. There is no stay.
No.
Be it mentioned that there is no interim order operating in this case. देख लीजिएगा. Interim order आएगा तो vacate कर दीजिएगा.
Serial 33, my lord.
Yes.
My lord, in this case, my lord, state is also party, my lord. Therefore, my lord, I cannot argue the case, my lord, being a state council. So I pray, my lord, 4 weeks time, my lord, to engage any other advocate, my lord, by the petitioner, my lord. 4 weeks time may kindly be allowed, my lord.
These are cases more than 5 years old, not even taken up for the first time.
Yes, lordship.
So,
my lord, being a state council, my lord, I cannot argue, my lord, against the state, my lord. I have intimated to my client, my lord, to engage any other advocate. He will, my lord, engage, my lord, other advocate who kindly give me 4 weeks time, my lord.
Mr. K.K. Singh submits that since he has been appointed as a state counsel, he cannot appear on behalf of the appellant, as the state is also a party to this appeal. In this appeal, party respondent in this appeal. Considering his, he submits that how much time?
4 weeks time may kindly be given.
4 weeks I will not grant. He may be granted. He submits. He prays that 4 weeks time may be granted. First up, considering his submission since the matter is of 2016, I am not inclined to grant 4 weeks. Full stop. 2 weeks time is granted to the petitioner to make an alternative arrangements.
Oblige, lords.
Yes. Any more? Call the list.
From Delhi call list under the heading orders with defect, serial number 1, second appeal 22 of 20, Mr. Avinash Kumar, Mr. Indrajit Sinha for the appellant.
In this case, I paid 2 weeks time to remove the defect, my lord. There's a delay in for 12 days, my lord. So we need to file an IA.
No, there's defect number 1.
That defect, my lord, with respect to valuation of the second appeal, my lord. That will be cured, my lord, within 2 weeks.
Defects to be removed within 3 weeks.
My lord, obliged.
Serial number 2, second appeal 24 of 20, Mr. Deen Dayal Saha, Mr. Virender Kumar for the appellant.
I pray for 4 weeks that will remove the defect, lordship.
4 weeks as prayed for is allowed to remove the defects.
Serial number 3, second appeal 25 of 20, Mr. Pratyush Lala, Mr. Amar Kumar Sinha for the appellant.
My lord, I pray, my lord, 4 weeks time to remove the defects, my lord.
4 weeks as prayed for to remove the defects.
Greatly obliged, my lord.
Serial number 5, second appeal 27 of 20, Mr. Abhishek Chandra, Mr. B.V. Kumar for the appellant.
My lord, I'm not aware what is the defect, my lord. However, some time may be allowed, my lord. 4 weeks time may be allowed.
3 weeks?
I am
4
not
weeks.
aware.
4 weeks?
Oblige.
Bhaiya Vishwajit Kumar prays for 4 weeks time to remove the defect. Prayer allowed, is this prayer allowed? The defects should be removed within 4 weeks.
Oblige, my lord.
Second appeal 28 of 20, Mr. Ranjit Kumar for the appellant.
Yes.
There are 3 defects.
Yes. Who is appearing? No one appears on behalf of the appellants. Full stop. There are office defects reported in this case. Full stop. The appellant is directed to remove the defect within 3 weeks.
Serial number 6, second appeal 30 of 20, Mr. S.J. Roy for the appellant.
Yes, Mr. Roy.
5 defects.
Unmute yourself.
4 feet short of.
Unmute yourself. Yes.
Lordship,
Yes. How much time you want to remove the defects?
at least 4 weeks because I misplaced the file. I have to reconstruct the file.
4 weeks
Lordship.
to remove the defects.
Serial number 7, second appeal 32 of 20, Mr. Kaushik Sarkel for the appellant.
Yes, who is appearing?
Good morning, everybody.
No one appears on behalf of the appellant. Full stop. There are offense defects which have been pointed out in this appeal. Full stop. Counsel, the appellant is directed to remove the defect within 4 weeks.
Serial number 8, MA number 33 of 20, Ms. Jaswinder Majumdar, Mr. Vikas Kumar for the appellant.
Your Lordship, I am appearing in this case, Your Lordship.
Yes.
There is a limitation.
No. There is a court fee. Shortage of court fee.
Court fee, Your Lordship. Court fee of 1498. Yes, Your Lordship. I'll file, Your Lordship, only
Within 3 weeks.
Oblige, Your Lordship.
Serial number 9, second appeal 34 of 20, Mr. Virendra Kumar for the appellant.
I pray for 4 weeks time to remove the defect, Lordship.
4 weeks to remove the defect.
Serial number 10, second appeal 36 of 20,
In this case also 4 weeks time may be granted.
4 weeks time granted as paid for to remove the defect.
under the heading for orders, serial number 11, second appeal 401 of 15, Ms. Neena Mukherjee, Mr. Bhaiya Vishnu Kumar.
Yes.
मेरा सीरियल नंबर 5 था मेरा
हो गया ऑर्डर देख लीजिएगा. Please don't interrupt the proceedings.
okay.
Yes. Madam, requisites of notice on R3 not filed.
Your Lordship, serial number 11, I appear for the appellant. With apologies, Your Lordship, I'm praying for some time.
You have not filed the requisites.
Your Lordship, notice was issued upon the respond number 3.
Yes.
On correct address, it could not be filed, my lords. We'll file it within 2 weeks, my lords.
This is an admitted appeal.
Lordship. So my sincere apologies for the inconvenience caused, Your Lordship. We'll file it within.
Which serial number?
Serial number 11, my lords.
You are appearing, serial number 11.
Your Lordship.
It is Bhaiya Vishwajit Kumar. SA 401.
Your Lordship.
You are not on record?
Your Lordship, I have not on the so file my appear.
Then who are you on? What capacity you are moving this case? Tell me. On what capacity you are appearing in this case? You don't hold the wakalatnama, you are no one.
Your Lordship.
Then? Tell me.
Your Lordship, I was instructed by senior counsel the file that belongs to Mr. M.K. Day. Unfortunately, he could not appear, my lords. Therefore,
He is also nothing here.
Your Lordship.
The wakalatnama is signed by one Leena Mukherjee and Bhaiya Vishwajit Kumar.
Your Lordship.
Where are they? Bhaiya Vishwajit Kumar is here. He was online. You are taking the name of the advocates who have nothing to do with this case. Where is Bhaiya Vishwajit Kumar?
Lordship, I'll just call him if it is passed over for few cases.
Pass over.
Serial number 12, Second appeal 498 of 15. Ms. Leena Mukherjee, Mr. Bhaiya Vishwajit Kumar, Mr. P.K. Paul. English also it's not fine.
Yes. Who is appearing? Pass over.
Serial 13, second appeal 623 of 15. Mr. Ayush Aditya. For the appellant, Mr. P.S. Pati, Mr. Anmol Anand, Mr. Rohan Kashyap, Mr. Ashish Kumar. For the respondent.
Your Lordship, I am appearing on the behalf of respondent number 8 and 9. Lordship, this case. Your Lordship, Mr. Ayush Aditya informed me that he is not in town and there is an IA 7418 for expunging the name of respondent number 5 and 6 as there is no legal heir and they expired in the year 2015 and 2017, Your Lordship. And they have no legal heirs, so their name must be expunged. IA number 7418 of 2021.
The requisites of notice on 789 filed after expiry of 3 weeks.
Office is directed to proceed with the requisites which have been filed for service of notice upon respondent number 7, 8, and 9. Okay, no one appears on behalf of the appellants. Liख दीजिएगा.
Serial number 14, second appeal 9 of 16. Mr. Yogesh Modi, Mr. Shubham Gautam. For the appellant.
Yes, notes, I am appearing. Notices were issued notes to the respondents. Perhaps it has come for the report of the service report of the notices.
R5 and 6 not residing at the address. R8 received by son.
Notice service of notice issued to respondent number 1, TO2 to 4 and 8 is valid. Full stop. Fresh notice on present and correct address by ordinary process to respondent number 5, 6, and 7 requisites 3 weeks.
Notes they belong to the same family, but it appears that they are the female members, but they have
Serial number 15, second appeal 16 of 16. Mr. S.
No one has received their notice.
Pardon, notes?
No one has received notice on their behalf.
Notes, then 4 weeks time may be granted to
4 weeks.
oblige the lordships.
Mr. S. N. Das, Mr. N.P. Thakur. For the appellant, Mr. Celeste, Mr. Ashish Kumar for the respondent.
My lord, इसमें 36 days का delay है, my lord.
R9 and 10 dead my lord. R1 and 28 appeared. There is a delay of
36 days delay है, my lord. Is IA number 3516, my lord.
Anyone appearing on behalf of respondent number 1 to 3?
Yes, minutes. We have filed the wakalat now.
On behalf of
1 to 8.
1 to 8.
Yes.
9 and 10 is dead.
I have no
Mr.
idea.
Salesh.
I will just check
appears
it
on behalf of
out.
respondent number 1 to 8. Full stop. It has been reported that respondent number 9 and 10 is dead. Full stop. The appellant submits that he will take appropriate steps. Full stop. Next paragraph. What is the IA?
IA number 3516, my lord.
How many days delay?
Condonation of delay.
36 days delay.
Yes, Mr. Salesh. Any objection?
No, I don't.
IA number 3516 of 2016. Full stop. This interlocutory application has been filed under Section 5 of the Limitation Act, trying to condone the delay of 36 days. Full stop. The reason of delay has been mentioned in paragraph 7 in 8. Full stop. Considering the said submission of the parties, I'm inclined to allow this IA. This IA I allow this IA. Full stop. The delay of 36 days is hereby condoned. IA allowed.
My lord, substitution petition के लिए my lord 4 weeks time, my lord.
Why should I? Why should I grant you time? The statute grants you time. The statute prescribes that if you don't file within time, what will happen? Who am I?
Serial number 16, second appeal 17 of 16. Mr. Chandrajit Mukherjee, Mr. Anjani Kumar, Ms. Shruti Shrestha for the appellant, Mr. Rajesh Kumar, Mr. Maninder Kumar Sinha, Mr. Amit Kumar for the respondent.
Yes.
R2, 3 and 2, 3 not found on the address.
R1.
And the IA is called for restraining for custody. KVD is also. Notice was filed on R2 and 2, 3 on.
R1 is on caveat. Anyone appearing on behalf of the respondent number 1? Let's file the caveats. Who is the counsel?
Mr. Chandrajit Mukherjee, Mr. Anjani Kumar, Ms. Shruti Shrestha.
Rajesh Kumar.
Mr. Rajesh Kumar, Mr. Maninder Kumar Sinha, Mr. Amit Kumar for the respondents.
Because no one appears on behalf of the appellant. None also appears on behalf of the respondents. Number 1, who is on caveats? Full stop. The office is next para. The office has pointed out that respondent number 2 and 3 was not found at the address mentioned in the notice. Full stop. Next line. Considering the aforesaid fact, I direct the appellant to take fresh steps for service of notice upon respondent number 2 and 3 on their present and correct address. Full stop. Requisites to be filed within 4 weeks.
Serial number 17, second appeal 74 of 16. Mr. Neeraj Kishore, Ms. Vandana Kumar Sinha, Ms. Vipul Divya for the appellant, Mr. Ashwar Prakash, Mr. Sri Prakash Jha for the respondent.
Yes, my lord, IA has been filed for condonation of delay, my lord, and upon notice they have appeared, my lord. IA number 6194 of 2018.
6194.
My lord.
Yes, Mr. Aishwarya.
Yes, my lord. I am appearing for respondent, my lord.
Any objection?
No, my lord.
How many days delay?
My lord, 8 days, my lord.
Yes.
Para 1, my lord, 8 days.
8 days. IA number 6194 of 2018. This IA has been filed to control the delay of 8 days, which occurred during filing of this appeal. Full stop. Learned counsel for the appellant submit that the delay is not intentional nor neither deliberate, and it took some time to consult the concerned lawyer and to follow the processes. Full stop. Considering the submissions made, I am inclined to allow this IA delay of 8 days condoned.
Deeply obliged, madam.
Serial 18, second appeal 81 of 16. Mr. Arun Kumar for the appellant, Mr. Ajit Kumar Singh, Mr. Pratik Sen, Mr. Gaurav Kumar for the respondents.
Yes. My lord, the IA, my lord, the 7589, my lord, for condemnation of delay of 34 days, my lord, in preferring the second appeal, my lord.
Who is appearing?
My lord, I am appearing. Ajit Kumar Singh.
You are appearing on behalf of all the respondents.
Respondent, my lord. I am appearing from the side of respondent.
All the respondents. How many respondents are there?
Sole respondent, my lord.
Sole respondents.
Sole
All
respondent.
respondent.
So what do you have to say about the delay of 34 days?
To whom you asking, my lord?
I'm asking to you. What do you say about the 34 days delay IA? IA 7589 of 2018, the delay of 34 days, the appellant has prayed to condone the delay of 34 days. What do you have to say?
I don't have problem, my lord.
Okay. For the council or the council for the parties, IA number so and so 7589. The council for the appellants raised to condone the delay of 34 days in filing this appeal. After hearing the parties, I find that it has been submitted that because of illness, the appellant could not contact the lawyer within time, which caused delay. First off, considering the statement made therein, I find that sufficient ground has been shown to condone the delay. Delay condone.
Serial number 19. Second appeal 82 of 16. Mr. Gautam Kumar, Mr. Sandeep Kumar Barnwal, Mr. Anil Kumar Singh for the appellant, Mr. Gautam Kumar Singh for the respondent.
Possible lots of few cases. Possible lots of few cases.
Who is appearing for the respondent?
Name of Mr. Gautam Kumar Singh appears for the respondent.
Pass over.
No.
Serial number 20. Second appeal 85 of 16. Mr. Aishwarya Prakash.
Yes, my lord. I am appearing for petitioner, my lord.
Yes.
इसमें हुजूर 29/4/19 को ही नोटिस का हुआ था. नोटिस हम लोग कर चुके थे हुजूर, लेकिन एपीआर तो अभी किया नहीं है.
Fresh notice by ordinary process of correct and present address of the respondent. Full stop. Requisites 4 weeks.
Serial number 21. Second appeal 87 of 16. Mr. Vishal Kumar Trivedi, Mr. Shesh Gautam, Mr. Shrey Mishra, Mr. Dipankar, Mr. Piyush Chitresh for the appellant, Mr. Kundan Kumar Ambasta, Mr. Bhaiya Vishwajit Kumar, Mr. Lalit Kumar Lal for the respondent. There are 2 IAs. IA for limitation of 22 days and the information that R1 is dead.
Write down IA number 4387 of 2021. This IA has been filed in terms of Order 22 Rule 10A, informing that respondent number 1 and respondent number 2 have expired. Full stop. The IA has been served upon the appellants.
My lord.
Copy of the IA has been served upon the appellants.
In my record.
Yes? Where is that IA?
for delay.
A copy of this IA has been served upon the appellants. Full stop. The aforesaid fact which has been mentioned in the IA is recorded. So stop. No further order will be passed in this IA. Yes, what is the other IA?
284 of 2016 was for delay of
192 days delay. Anyone appearing? Anyone appearing on behalf of the respondents?
My lord, though my name is there, my lord,
Yes.
but the brief is not with me, my lord.
3, 4, 5, 6, 7, 8, 9. Anyone appearing? Let's see whom you are appearing. Bhaiya Vishwajit.
I appeared, my lord, along with Mr. L.K. Lal, my lord.
Yes, you are appearing on behalf of the respondents. Then, what is your instructions?
Then I have to seek instruction, my lord. I have to file a.
What about the delay?
A reply. I have to file a reply, my lord, since it is used delay, my lord.
182 days delay.
182 days.
Bhaiya Vishwajit appearing on behalf of the respondent. Praised for some time to file a rejoinder to IA number 2894 of 2016. First up, prayer allowed. Is this case after 4 weeks?
Obliged, my lord. There were two cases, my lord, which has been passed.
Wait for the last orders cases. Yes.
Serial number 22, second appeal 89 of 16. Mr. MD Lal, Mr. Bhaiya Vishwajit Kumar, Mr. Sachin Mahato for the appellant, Mr. Indrajit Sinha, Mr. Suraj Singh, Mr. Ajay Kumar Shah, Mr. Arpan Mishra for the respondents.
This is an admitted case below the notice, and the respondent number 1 has accepted the notice below by Mr. Indrajit Sinha, my lord, and the others were notices were issued.
Is appearing on behalf of all the respondents?
No, I'm only for one fund.
You are only for?
1 minute. I'm only for one respondent, my lord.
Which respondent?
There are so many name of the lawyers appearing.
Respondent number 1, my lord. Order sheet reflects my name, my lord. Order dated 3/12/2018.
You are appearing on behalf of respondent number 1.
Yes,
who is from 3, 4, 5, and 6?
All are same family, my lord.
Received by mother. Received by mother. The notice which was issued to respondent number 2 has been received by respondent number 2 himself. To herself. So far as respondent number 3, 4, 5, and 6 is concerned, it has been reported that the notices were received by their mother. It has also been mentioned that the family is joint family. Considering the aforesaid fact, the notice upon respondent number 2, 3, 4, 5, and 6 is deemed to be validly served.
Obliged.
Serial number 23, second appeal 91 of 16. Mr. Lalit Kumar Lal for the appellant. Respondent number 21, 22, and 23 is there. Okay.
No. Mr. Lalit Lal is no more. Where Vishwajit, he will appear in this case, or you?
Lordship, in this case, I am appearing for the respondents, Lordship.
No, the appellant.
For the appellant, Mr. L.K. Lal is. Item number 21, Lordship. Oh, no. 23. Oh. It is item number 23.
It is Mr. Lalit Lal, the brief of Mr. Lalit Lal, L.K. Lal.
Notice will go, my lord, since only advocate is there on the record.
So you're not appearing. I'm issuing notice to the appellants.
My lord.
Office is directed to issue notice to the appellants, considering the fact that it has been considering this fact that it has been informed that Advocate Mr. L.K. Lal has expired.
Serial number 24, second appeal 128 of 16. Mr. Ashok Kumar Sani, Mr. Vikesh Kumar for the appellant, Mr. Rohitash Roy, Mr. Tarun Kumar Mahato, Mr. Vibhor Mayan for the respondent.
IA number 7728 minute for condonation of delay of 16 days minute. The notices were issued to the respondents. My learned friend is appearing minute. 16 days delay. Cause in preferring this appeal minute. Mr. Tarun Kumar is appearing for the respondent.
No,
Yes,
some of the respondent has died.
I do not know who are they, and I will inspect the record and take down. Then I have to take a step for
Just a minute.
Next case. Next case.
Okay, Likhe. The notice which has been issued to the respondent is validly served. Also, next para. IA number so and so. Anyone appearing?
I am appearing for respondent number 3, my lord.
Respondent number 3.
Yes, my lord.
What do you say about the limitation? How many days? 16 days.
16 days.
This IA has the delay of 16 days in preferring this appeal. Full stop. The grounds for delay has been mentioned. Paragraph 5. Full stop. Considering the submission statement made in paragraph 5, I am inclined to allow this IA the delay of 16 days as the grounds are sufficient to put the same. Full stop. The delay of 16 days is condoned. This IA stands allowed.
Serial number 25, second appeal 131 of 16. Mr. Ashiv Kumar Sani for the appellant.
In this case, the delay of 8 days IA has been filed for condonation of delay, and notices were directed to be issued in terms of order dated 2/12/2019. I took this step on 16/12/2019. And no name is appearing in the list, most probably nobody has appeared. 8 days delay in preferring this appeal.
In spite of service of notice, no one appears on behalf of the respondent. Full stop. This IA number so and so has been filed to condone the delay of
8 days.
8 days, 9 days.
9 days, yes. 9 days, sir.
The grounds have been mentioned in paragraph 4. Full stop. Considering the grounds in paragraph 4, I find that sufficient grounds have been sufficient grounds are there to condone the delay condone. IA allowed.
Passed over cases under the heading orders. Serial number 11, second appeal 401 of 15. Ms. Veena Mukherjee, Mr. Bhaiya Vishwajit Kumar for the appellant.
My lord, I am appearing, my lord.
You have not taken steps. You have not complied the order dated 18/11/2021. How much time?
2 weeks more time, my lord.
I'm giving you 3 weeks, but it will be peremptory.
My lord.
3 weeks further time is granted to the appellant to comply the order dated 18/11/2021, failing which this appeal against respondent number 3 will stand dismissed without further reference to this bench.
Serial number 12, second appeal 498 of 15, Ms. Leena Mukherjee, Mr. Bhaiya Vishwajit Kumar for the appellant.
Same. Yes. Three weeks further time by way of last indulgence is given to the appellant to comply the order dated 25/11/2021.
Obliged, man.
Just a minute. Failing which, this appeal, this appeal will stand dismissed without further reference to this bench.
Serial number 19, second appeal 82 of 16, Mr. Gautam Kumar, Mr. Sandeep Kumar Bandwal for the appellant, Mr. Gautam Kumar Singh for the respondent.
This matter has already been admitted on 24/9/18.
Yes.
The notice issued to the respondent. And it appears that Mr. Singh is appearing on behalf of this, Mr. Gautam Kumar Singh is appearing on behalf of the respondent.
The notice from the office note, it is apparent that the notice has been properly served upon the respondents. Yes.
Under the heading hearing under order 41 rule 11 of CPC, serial number 26, second appeal 528 of 15, Mr. Manoj Kumar number 4 of for the appellant.
Yes.
May please, Your Lordship, I am appearing in this case for the appellant, Your Lordship.
Yes.
Yes, Your Lordship. The appellants were defendants before the trial court, and the suit was for partition of the super party.
Yes.
The case.
Yes.
Yes, Your Lordship. The case is that in the Ganjar settlement, the land in question was recorded in the name of 5 brothers, out of which 3 brothers were died issueless. So the entire property devolved upon 2 brothers, Chatur Tudu and this Jalpa Tudu. The plaintiff before the trial court was the descendant of Jalpa Tudu, and I am. The defendants were the descendant of the Chatur Tudu. Now, in the final publication of the records of right, name of Jalpa Tudu was not there, only my name was there, against which no suit under section 25 of the Santhal Pargana regulation, settlement regulation was preferred. In view, so this record of right was finalized, and my name is there. So the suit is not maintainable itself at the relevant point of time. The name of the Jalpa Tudu was not recorded in the records of right in view of the fact that Jalpa Tudu had solemnized marriage in Ghar Jamai form of marriage. And under the Santhal customary law, Ghar Jamai, if a marriage is solemnized under Ghar Jamai, he became he has a right of inheritance in his father's-in-law property, not in the natural right. And subsequently, Jalpa Tudu, after some quarrel with his father-in-law, returned back to his natural guardian. But even the Jalpa Tudu did not claim any right or any share in the property. Now their descendant is claiming only after the final publication of records of right. So the suit of partition is itself not maintainable. My first substantive question of law is, Your Lordship, is there. And second thing is, Your Lordship, that the trial court has framed as many as 8 issues, in which the issue number 4 is very important. Issue number 4, whether Jalpa Tudu was married in Gharjamai form and according to Santhal customary, his right to parental property seized. And while deciding this issue, no specific finding has been given by the learned trial court, and only it has been recorded that
I am appearing for petitioner Miller 4 weeks time. हुजूर इसमें सीनियर काउंसिल मिस्टर जेपी झा आर्गुमेंट करेंगे हुजूर, उनको हार्ट अटैक हो गया है, इसलिए वो आईसीयू में है हुजूर।
कौन केस में?
ये 27 में मिलर्स, 27 में
27 है, दिस इज 26।
अच्छा, सॉरी मिलर्स, सॉरी मिलर्स।
Now, my lord, if your lordship will see the operating portion of the judgment of the trial court, it running page.
Yes.
Running page 18, Your Lordship, internal page 7. Running page 18, internal page 7.
Yes.
Now, from
very first of the record.
Yes, Your Lordship.
Yes.
And prior to that, in the first paragraph, it has been stated that now I would like to go further deep to the Santhal customary law of inheritance. There is a custom in Santhal that a person who has no son can marry his daughter as a Gharjamai form, keep his son in his own house as a son, and in that case, Gharjamai has also right of inheritance of his father-in-law as a son. So this is the customary law that is prevailing in our court. Now, the second paragraph. From perusal of records as clear as the day that the defendants have not produced any oral or documentary evidence regarding inheritance of Jalpa Tudu as Gharjamai at village Dhanbasa from his father-in-law. It is pertinent to mention here that when a person goes to in-law's house as Gharjamai, the villagers and Gotiya, the male lineal person, always opposes him, but the defendants have failed to produce any such person to prove that the father of the plaintiff have inherited the land of his father-in-law as Gharjamai. Moreover, the defendant have also not produced any witnesses to prove the customs of the Gharjamai form of marriage followed by the father-in-law by villagers at the time of marriage of Jalpa Tudu at village Dhanbasa. They have not produced any independent witness or common relatives of the party to say that now the marriage of the Jalpa Tudu was solemnized in Gharjamai form. Rather, they have also only stated the only heard story of Gharjamai form of marriage of Jalpa Tudu. Because this Jalpa Tudu marriage was solemnized in 1938, much before. Now it is more than 90 years earlier. Lords. On the other hand, and now in this way, from the critical analysis of the entire evidences and circumstances as well as documents.
Read from the judgment. Read from the very first paragraph. Let us start from the first paragraph.
From the findings, Your Lordship, very first paragraph. Yes, Your Lordship. This is the suit for partition.
Yes.
Yes, Your Lordship. This is the suit for partition of half share in the suit property described in schedule of the plaintiff in favor of the plaintiff, and also for carving out a separate takta of his half share by appointing a mean commissioner, and for final decree in respect of carved out half share along with the cost and other reliefs. From resume of the facts set out here in it, it clearly emerges that the parties are Santhal and governed by their customary law of inheritance. The land of Jamabandi number 5 of Ganges settlement. This is the recent Jamabandi, corresponding to the Jamabandi number 20 of Moja Saraidi, fully described in the schedule of the plant, stands recorded jointly in the name of Chatur Tudu, Ragda Tudu, Chalpa Tudu, Ram Tudu, and Matla Tudu, son of Bali Tudu, in the Ganges settlement. But in the current survey settlement, it is recorded in the name of Sati Tudu, son of Jalpa Tudu, Chatur Tudu, Derek Tudu, Munshi Tudu, son of Chota Bali Tudu, Parna Tudu, Malin Tudu, Udin Tudu, Iswar Tudu, and Masi Charan Tudu, son of Phagu Tudu, Lakhi Tudu, and Babulal Tudu, son of Suku Tudu. A genealogy has also been given in the plant showing the inter-se relationship of the parties. Further, the case of the plaintiff is that the recorded tenant of the Ganja settlement, namely Narayan Tudu, Ragda Tudu, Ram Tudu, and Matla Tudu, died issueless, and their interest devolved upon the heirs of their two surviving brothers, namely Chatur Tudu and Jalpa Tudu. Only two sons, all the property devolved on the two sons. The plaintiff is the son of Jalpa Tudu, whereas the defendants are the heirs of Chatur. As son, according to customary law of Santhal, the parties are entitled to their half share each in the suit property, and they are in the joint cultivating possession of the suit property according to their convenience. There has been no partition of the suit land by meets and bounds. The further case of the plaintiff is that in the current survey settlement, this is important, Your Lordship. In the current survey settlement, the defendants have managed to get the lands recorded in their possession in collusion with the settlement amine. It has only by saying that they have managed to get will not do the purpose, Your Lordship, because they have to file a suit for challenging the final settlement. It has also been stated in the remarks column of plot number so and so position of the years of the last recorded tenant Chatur Tudu and others was recorded. But in respect of plot number so and so, Chatur Tudu, Derek Tudu, and Munshi Tudu, sons of Chotalal Bali Tudu, have been recorded. The plaintiff demanded amicable partition of the suit property in February 2006, but the defendant refused, hence this suit. The defendants appeared and contested the suit. I am appearing for the defendant. Except defendant number second party by filing WS stating inter alia that the suit is not maintainable, the plaintiff has no cause of action and also barred by the law of limitation, estoppel, and the second suit party is the deputy commissioner, because under the SPT Act, this is the necessary party in all the suits. The further case of the defendant is that in the present survey settlement, the land of Jamabandi number 20 corresponding to old Jamabandi number 5 of Mr. Ganjar's settlement, the name of the plaintiff has not been recorded entirely in separate or in joint possession. But in connivance with the settlement staff, the plaintiff has got recorded some plots in his name, which has been possessed permissibly by his father Jalpa Tudu. His father Jalpa Tudu was married with Sumi Murmu, daughter of Phagu Murmu of Dhanbasa, PS Raneswar district, Dumka, in Gharjamai form of marriage. In 1938, he went to Dhanbasa and began to live with his father-in-law, but due to friction with his father-in-law, he returned back his parental home at Saraidaha with his wife and son. Plaintiff, he has given some piece of land in cultivation for his livelihood or pity, and the defendants maintained the plaintiff mothers because of love and affection since her death in 1997. The further case of the defendant is that after the death of the other recorded tenants, Satu Tutu, the surviving recorded tenants inherited the suit land and came in peaceful physical cultivating position, and the father of the plaintiff has no right, title, and interest in the suit property, but the plaintiff remained in the cultivating position of those plots. Those plots were given himself by these defendants, your lordship, as permissive possession, because he returned back to his parental house. So for his livelihood it was given. Were given by the defendant to the plaintiff father for his inheritance. Hence, the plaintiff is not entitled for any relief claim. Thus, the prayer for dismissal of the suit. Having regard to this one, the following issue were is is the suit maintainable? Has the plaintiff valid cause of action? Now, third and fourth issue is important. Has the plaintiff validly inherited the property of Jalpa Tudu? And fourth issue is whether Jalpa Tudu was married in Gharjamai form and according to Santhal custom, his right in paternal property seized. And now there, after some formal issues were found that like that where unity of position and defendant party have absolute right title interest over the suit property or not. These are now the finding with respect to issue number 3, 4, and 3, 4, 5, and 6. These issues are interlinked with each other, so for the sake of brevity and convenience, they are taken up together. It is the case of the plaintiff that the suit land pertaining to Jamabandi number 5 of Moses Sarai Deha was recorded jointly in the name of so and so, so and so, so and so. In this Ganja settlement, the recorded tenant Narayan Tutu, Ragda Tutu, Ram Tutu, and Magla Tutu died issueless, leaving behind their two brothers, namely Chatur Tutu and Jalpa Tutu. As such, both the surviving brothers Chatur Tutu and Jalpa Tutu inherited the suit land and came in peaceful cultivating possession. The plaintiff is the grandson of the recorded tenant Jalpa Tutu, whereas the defendants are the legal heirs of Chatur Tutu. Hence, the plaintiff is entitled for the half share in the suit property. The suit property is still joint and no partition took place by meets and bounds between the parties. They have been cultivating the suit and fully on the basis of convenience. On the other hand, the defendants have pleaded that there is no question of any unity of title and possession of the parties over the suit land. The plaintiff has no right, title, and interest of the suit property. His father, Jalpa Tudu, was married to Sumi Tudu in Gharjamai form of marriage. He had been living with his father-in-law, but after some time, a friction arose between them, and Jalpa Tudu returned back to his parental house. The defendants have allocated some plots to Jalpa Tudu for his livelihood. As such, according to Santhal customary law, Jalpa Tudu has lost all his right, title, and interest in the suit property. Since the date of his marriage in Gharjamai form, hence the plaintiff cannot claim right, title, and interest in ancestral property, that is the suit property. I have gone through the oral as well as documentary evidence available on record. It is admitted case of the parties that the suit land was recorded in the name of Chatur Tudu, Narayan Tudu, so and so, in the Ganja settlement. Also, an admitted case of the parties that the defendants have not claimed previous partition, rather they denied the right, title, and interest of the plaintiff. It is pertinent to mention here that the burden of proof lies on the party who assert it. As such, the burden of proof that Jalpa Tutu was married in Gharjamai form of marriage lies on the defendants who asserts this. Now they have discussed I would like to discuss and scrutinize the evidence oral as well as documentary laid by the parties thoroughly at first. DW1 Iswar Tutu has admitted in his cross-examination that the name of Jalpa Tutu and Chatur Tutu were recorded in Parcha. His father Chatur Tudu died leaving behind his three sons, namely Bali Tudu, Bhoga Tudu, and Supa Tudu. They also died and the land of Chatur Tudu was divided among his three sons in equal proportion before the new survey settlement, and the plaintiff has got the land of his father Jalpa Tudu. He further stated that he has heard about marriage of Jalpa Tudu in Gharjamai form of marriage from his father. He also stated that his father spoke that Jalpa might have been living in his sasural about 6 years after he returned back home. He denied that Jalpa was not married in Garjamai form of marriage. DW2 has admitted in his evidence that the parental line of Chatu Tudu and Jalpa Tudu are running, but he failed to say as to when Jalpa Tudu died. He stated that his father has told that Jalpa was married in Garjamai, but he did not say the time of death of his father. But he has admitted that he remembered the time of death of his father. He also stated two types of marriage, namely Ghar Jamai and Ghar Di Jamai form. From further, he stated that Ghar Jamai returns back to his parental home, but Ghar Di Jamai returns back to his parental home, but Ghar Jamai never returns back. But in para 24, 5 of the cross examiner, he has admitted that after death of Narayan Tudu, Raghal Tudu, Ram Tudu, and Metla Tudu, their land was inherited by Jalpa Tudu and Chatu Tudu. And the only son of Jalpa Tudu has already got his share. Now, DW3 stated that his DW1 is the grandson of this Chatu Tudu, who has inherited all the product and recently served a settlement. So his evidence is also important, is because he has a special means of knowledge under Section 50 of the Evidence Act. Now, DW3 stated that his father, who died 4 years back from the date of evidence, has told him that Jalpa Tudu was married in 1938.
Mr. Rajiv, just a
Lord,
minute. This Chatur Tudu and Jalpa Tudu is the son of
Bali Tudu.
Bali Tudu. So
Yes,
Bali
sir.
Tudu had 5 other sons also. The 3
Also
other
5 other. Yes, 5, 6 other, altogether 6 sons, out of which 4 sons died issueless.
4 sons died issueless. So they died issueless before the present service settlement?
Yes, sir. So before the Ganges settlement.
After
the Ganges settlement. After the Ganges settlement and before this recent service settlement.
Okay.
So only the 2 surviving brothers, Chatu Tudu and Jalpa Tudu. Okay. So the entire suit property devolved upon these 2 persons. Out of which the Jalpa Tudu married in Ghar Jamai form, according to the dependents. Now, in DW3, he stated that his father, who died 4 years back, but he did not say that which plot was given to Jalpa.
Now, just answer one question.
Lordship.
There were 6 sons.
Lordship.
4 died issueless.
Lordship.
Before the service settlement.
Yes, before the recent service settlement.
Now tell me, when do a succession open?
Lordship.
Answer this. When does a succession opens?
Succession after death of the 4 sons of the recorded tenants.
After death of the 4 sons, the property automatically devolved upon Chatur and Jalpa?
Chatur and Jalpa.
So once the property devolves upon Jalpa, how the property you can disinherit him?
Disinherited because of the Santhal customary law. Because Santhal
so show me the Santhal customary law that a property which has already been devolved will be disinherited.
Yes, Your Lordship. That is the.
It is not a question that the property has not devolved upon him. The question is property has devolved, then it is going away from him. Show me that.
Yes, Your Lordship. That has come in the judgment also, and in the Ganges settlement, it has been pointed out that when a person died, married in Garjamai form of marriage, he lost all his right and interest.
He will not inherit. He will not inherit. But the question here is, he has already inherited prior to that marriage.
then Jalpa Tudu has not claiming. His heirs are
Merely
claiming.
not claiming will not disentitle anyone. Once the property, see, X, suppose the property has devolved upon X.
Yes.
And when it has already been devolved, thereafter he has married in a Ghar Jamai form. Show me that
Yes,
his
sir.
inheritance will be nullified.
Yes, Your Lordship. That exactly the Santhal customary law
Show me
says
you have not
that
proved that
if
law.
a person has a right in the property
His marriage, tell me, when did his marriage taken place?
in 1938, and in the judgment, if Your Lordship will
And
see,
when did his brother die? When did his brother die?
brother died. That has not come in evidence, Your Lordship. That has to record has to be said, and no party have come in has deposed
So in
evidence
cancer
regarding the
settlement, in cancer settlement, what was the record? In whose name
Lordship.
the property was recorded?
In the recent settlement, all the properties was recorded in the name of the defendant.
No, in cancer settlement it was recorded.
Recorded in all the 6 brothers.
In all the 6 brothers.
Lordship.
In cancer settlement, it was recorded in all the 6 brothers.
At the relevant point of time, all the 6 brothers was alive.
Okay. Now tell me,
Yes,
that means this 4 brother died sometime in between the cancer settlement and the recent settlement.
This recent settlement. Yes.
Now, if it is your case that Japla Tudu had not inherited anything, then the date of death of this person and the date of marriage of Japla Tudu is important as per you?
Yes, sir. Yes, sir. So my submission is
evidence.
Yes, sir. So my submission is that Japla Tudu inherited the property because the property devolved to the Jalpa Tudu, but he lost all his right title after Ghar Jamai form of marriage.
How can one?
And he will be inherited.
Just a minute. It is then you say, see, there are two things. Suppose a property belong to the father. So the property will be inherited by the son only after the death of the father. As per your customary law. Now, during the lifetime of the father, if the son is married in a Ghar Jamai form, then he goes out of the family.
Lordship.
Yes. And after then, in that case, after the death of the father, this person who is going out of the family will not inherit.
Lordship.
This is one scenario. Come to the second scenario, where the father dies before the marriage.
Lordship.
Then what happens? Then the property is automatically inherited by this person. Now, thereafter, he marries in a Ghar Jamai form. Then show me the customary law that the property which has devolved upon him will be reverted. Is this the custom?
Yes,
have you pleaded this custom?
Yes, this is the custom, Your Lordship, and the second, third situation.
This custom.
The third situation is if the father has the right of the property, the father himself married in a Ghar Jamai form of right.
No.
Form of marriage.
This is not a question of father. This is not a question. Now,
because Jalpa Tudu,
inheritance. Just listen to me. Inheritance cannot be left open. It takes place immediately on the death.
Lordship. But Jalpa Tudu was the recorded tenant. He was the recorded tenant.
Jalpa was the recorded tenant. You say because of his marriage he has lost.
Yes.
How can that be? Once he is recorded, he has inherited. How can you disinherit him? This is my question.
Yes. This is the custom.
You can say, you could have said that he, because of the marriage, he will not be eligible for inheritance. Inheritance when he has not, when the property has not devolved upon him. But here the question is, the property has devolved upon him already prior to that.
Yes, Your Lordship. And after this custom, that has been dealt by the trial court in page 18, Your Lordship, that I have read just, Your Lordship, page 18. And now abstract of the Ganges settlement, I may be permitted to read, Your Lordship.
Now, see, there are two things. One thing is, as per the customary law, a person who marries outside and settles as a ghar damat is not entitled for inheritance. This is one. This is the fact. This is the law you are saying. This is the customary law.
Customary law is,
but
he shared in the parental. He lost all his share in his parental house. Rather, he has a right of inheritance.
Question is, he loses the right to inherit. But question is, inheritance has already taken place. The question over here is, you also admit that the inheritance has already taken place. When the inheritance has already taken place, then the property he has inherited becomes his property. Now you show me any law that it will revert. This is a question of reversion.
Yes, sir. That I will show from the Ganges.
Inheritance. This is not a question of inheritance because the inheritance has already taken place. Now show me the customary law that it will revert.
Yes, sir. So the customary law, I will refer the customary law from the Ganges settlement, Your Lordship. If Your Lordship will allow me to some time, Your Lordship, because
you have not pleaded this. If this is Mr. Prasad. Mr. Prasad, if this is a customary law has to be proved and pleaded and proved.
Yeah, no. That I have taken in my substantial question of law.
You have taken the plea, Mr. Prasad. Just understand this fine distinction. You have taken the plea that he is not permitted to inherit. But your fact says that he has already inherited.
No, Your Lordship. Not a question of my substantial question number C. May kindly have a look, Your Lordship.
Yes.
Whether the learned court below have committed an error in not appreciating the contention of the appellant that as per Santhal customary law, Ghar Jamai married son-in-law inherit the property of his father-in-law. So inheritance doesn't, I am not saying about inheritance in parental house, does not inherit the property of his natural father, and it has come in evidence in unequivocal term that Jalpa to do married in Ghar Jamai form of marriage, and as such, according to Santhal custom, his right to paternal property ceased even if he returned to his paternal house.
His right to inherit ceases. But here the question is, he has already inherited. That stage is already over. How can you go back to that particular stage of inheritance when the inheritance has already taken place?
Yes, Lordship. There are judgments also, Your Lordship. If Your Lordship will give some time, then I will show Your Lordship judgment that he all this share. His share in the property of his parental property will ceases, and he will be entitled for his share father-in-law property.
The basic principle is succession or inheritance takes place immediately on the death of the recorded tenant. It cannot be deferred. It cannot be kept. There cannot be any gap between death and succession. Immediately dies. Immediately on the very next second, the succession takes place. Now, over here, it is your case that succession had taken place and Japla Tudu was recorded as the tenant. That means inheritance has already taken place. Now you say that he has married. Now, if he has married, you say that he will not be entitled to inheritance. That inheritance had already taken place. Now, your case practically is that because of that marriage, whatever he has inherited will revert. Because inheritance has already taken place as per you. You understand what I am trying to say?
Yes, Your Lordship. Yes, I understand.
If B and C is the son of A, B and C will inherit the property immediately the moment A dies. Now, on the death of A, B and C has inherited the property, inheritance come to an end. There is no question of deferred inheritance. Now, you say that if B marries and goes as a Ghar Jamai, he will not be allowed to inherit. Now the question is, the inheritance has already taken place. Then your case is that he will be, the property will revert to.
No. My submission is that A has a right in the property by virtue of being a recorded tenant. He
Yes.
married in. Now I'm not saying about B and C. A has a right by virtue of his recorded tenant, by virtue of a recorded tenant. He married. He married in Ghar Jamai. A itself married in Ghar Jamai form of marriage. So he.
No. Let us be the fact. Japla to do.
Japla to do is recorded tenant.
In the Kansas settlement, the name of Japla to do is there.
There, yes, sir.
That
He
means
is recorded tenant. He has a right.
That means inheritance has already taken place. The right has already accrued, devolved upon him.
Yes.
Then you say that Japla to do married.
Lordship.
Now, when a right has already devolved upon him, the land is in his name, he has devolved upon him. How can the inheritance has already taken place? Then you say that the property will revert. Your claim is that on marriage the property will revert. See, just a minute. As it is your case that the other four died issueless. So
yes, sir.
The other four were also the owner of the property. They were recorded tenant.
Lordship, yes.
So the property which is already devolved, now what happens? It will revert. It's a question of reversion on his death.
Yes.
The reversion to other two on his death. Similarly, your case is that it is a reversion on marriage. Do you understand?
Lordship,
is it not? See, there is a reversion. The reversion on basis of death and reversion on basis of marriage. These are the two grounds you are taking.
Yes, Lordship.
Japla Tudu and your father inherited the property by way of reversion on ground of death. Now you are claiming reversion on the basis of marriage. Is it not?
Yes.
Show me the customary law which you have proved that there is a reversion on basis of marriage.
Yes, Your Lordship. That is the yes, Lord. If Your Lordship will see the Santhal Pargana SPT Act.
Show me.
Yes, sir. So the Ganjar settlement, in the Ganjar settlement, it has been clearly stated
that he will not inherit.
He will not inherit. He will lost all his right and share in his property derived from his paternal.
Show me that.
Yes, sir.
Show me that.
Yes, sir. So that is the Ganjar settlement.
And even taking it to be correct, both the courts have held on evidence that you have failed to prove that the marriage was in a Ghar Jamai form. This is a question of fact.
This is the question of fact. I am not going into that. Yes. But my substantial question is that when the final publication of records of rights has published, then the only remedy is section 25A of the Santhal Pargana Tenancy. 25A of the Santhal Pargana Settlement Regulation 1920.
Read that.
Yes, Sir Lordship. And so suit is not maintainable. 25A
of the Act
of the Santhal Pargana Settlement Regulation 1872.
1872 वाला दीजिए. संथाल परगना सेटलमेंट रेगुलेशन.
उसमें इसी में है, संथाल परगना टेनेंसी मैनुअल में ही है, इसी में.
मेरा पास नहीं है, देखिए तो संथाल परगना टेनेंसी मैनुअल कुछ है. Just check it. I have got the Santhal Pargana Tenancy Law. That's a big volume, 2 volumes. You read that.
Yes, sir. 25A suits to contest settlement of such decision, where only the rights of zamindars and other proprietors as between themselves and the a suit may, unless it is barred by Section 13 of the Code of Civil Procedure, be brought in a court established under the Bengal, Agra, and Assam Civil Courts Act to contest the finding or record of the settlement officer within 3 years from the date of the final publication of records of right or of the final order of the revenue court, but no such suit shall be brought in any court after the expiration of 3 years from the date of such. So the only when a final publication of records of right has been published, in which the name of the plaintiffs were not there, the only remedy. So by filing a partition suit, we cannot inherit any property because the record of right has already been prepared by final publication of records of right in which his name is not there. Now the only remedy left with him is to challenge the final publication by filing a suit before the revenue authority, before the SDO lordship, under the Santhal Pargana Tenancy Regulations.
This is 25A of the regulation.
Lordship. So the suit itself is not maintainable, was not maintainable. So this is my substantial question.
Okay. That's all.
Lordship.
Dismissed. Judgment to follow. Undictated.
Obliged.
Serial number 27, second appeal 125 of 16.
4 weeks time.
Yes. Who is suffered heart attack?
Yes, Mr. Senior Counsel Mr. JP Jha को हुआ है.
When?
इसलिए 4 weeks का समय चाहिए होगा.
नहीं, when has he suffered heart attack?
नहीं है, वो ठीक है हुजूर.
ठीक है ना?
हाँ
हुजूर उनको स्टेंट लगा था 15-20 दिन पहले.
Okay. On the health of senior advocate Mr. JP Jha, prayer has been made to adjourn this case. The respondent has also got no objection. Yes, please, for the respondent.
I am for the respondent.
The respondent has got no objection. First up, this case is adjourned for 4 weeks, 6 weeks. 6 weeks.
Obliged.
Serial 28, second appeal 132 of 16. Dr. Gyanendra Kumar, Mr. Ganesh Pathak, Mr. Rohit Ranjan Sinha, Mr. Pratyush Kumar for the appellant.
Lords, this is a second appeal arising out of a money suit, Lords. The suit was decreed, thereafter it was confirmed in appeal, and thereafter we are in second appeal, Lords.
Yes.
The suit was filed by 2 persons, plaintiffs, saying that the uncle, that is the defendant number 1, had made such 2 fixed deposits, each in the name of 2 plaintiffs, with the defendant number 2 bank. Yes. And against these 2, and the uncle was the guardian of these 2 plaintiffs.
Okay.
With regard to this 2 fixed deposits. And thereafter, the uncle took a loan.
Read the trial court judgments.
Lords. The plaintiff case is that both the plaintiffs are brothers and are members of joint Hindu Mitakshara family, and the plaintiff number 1 is the manager and karta of the said joint family. The plaintiff number has filed the suit on behalf of the plaintiff himself and on behalf of his brother plaintiff number 2. The defendant number 1 is the uncle of the plaintiffs. The plaintiffs have stated that Mahadevi was the mother and Shivnandan was the father of late Ram Sundar and defendant number 1. The said Ram Sundar was the father of the plaintiff and the plaintiffs hona chahiye, and the defendant number 1 is the father's brother of the plaintiffs. The plaintiff's father died before the death of his parent, that is Dada, an accident in so and so where he was an employee, and the case under so and so was started. Workman compensation started, and the compensation was paid to the mother of the plaintiffs or on behalf of herself and other defendants, including the plaintiffs. After death of Sundar, after death of ये कट गया father
Ram Sundar.
Ram Sundar, Shiv Nandan died, and Mahadevi, the grandmother of the plaintiffs and the mother of the defendant number 1, had a and holding number so and so at Jugsalai, and she executed a power of attorney in favor of her son, defendant number 1, and the defendant number 1, as attorney of the Mahadevi, sold the said house and holding as a consideration of 40,000 only. Out of these amounts, the Mahadevi gave 10,000 to the defendant number 1 and 10,000 to the plaintiff.
10 out of the said amount, Mahadevi gave 10,000 to the plaintiff number 1 and 10,000 to plaintiff number 2, who were minors.
Who were minors at the time. The defendant number 1 deposited the said money in favor of the plaintiff in 2 fixed deposits as detailed in Schedule A of the plaint. The plaintiffs have stated that the defendant number 1 was guardian of the plaintiffs of the said fixed deposits. The money was deposited in Kandra branch of Punjab National Bank. The defendant number 2 on 4/2/82, the said deposits are said to be matured on 28/5/85 and have already matured. The case of the plaintiffs is that when they went to inquire about the said to fixed deposits in the office of the defendant number 2, they were informed that the defendant number 1 had taken the loan of 7,500 only from each of the said fixed deposits and has not paid the same. It has been stated that defendant number 1 has invested the same money in the workshop at Adityapur, standing in the name of the wife. It is also learned that the age of the plaintiff number 1 has not been properly noted and he has shown as minor even now, although the plaintiff number 1 was born on 15/10/65. He is major. Further case of the plaintiff is that they were not paid the interest of the said fixed deposit, although the same were realized by the defendant number 1 before he took loan. The plaintiff has stated that the defendant number 1 has no right or legal authority to take loan from the defendant number 2 bank against the fixed deposit in favor of the plaintiffs. He has stated that the said loan taken by in collusion with the defendant number 2 bank, and defendant number 2 bank has no right to advance the loan against the deposit of the defendant number 1. Further, on permission of any court or consent of the natural guardian, mother of the plaintiffs or the plaintiffs was taken for the said loan. The said loan was never required or utilized for the benefit of the plaintiffs, and the interest realized by the defendant number was never paid to the plaintiffs, and they were misappropriated by the defendant. Hence, the defendant number 1 is liable to compensate the plaintiff for all the wrong by the defendant. Plaintiffs have stated that they are not liable for the wrong done, and defendant number 1 and 2 are not liable for loan taken. Sorry, my lords, that they are not liable for the wrong done by defendant numbers 1 and 2 and are not liable for loan taken by the defendant number 1 from the defendant number 2, and the fixed deposit of the plaintiffs are not liable to be burdened by the illegal acts of defendant number 1 who have taken the loan for these personal benefits, and no part of the loan was required or spent for the benefit of the plaintiffs. Therefore, it has been claimed by the plaintiff that both the defendants are liable to pay the full amount of the deposits made in the name of the plaintiffs with the interest, and defendant number 2 has no right to deduct the amount from the deposit amount, and thus the plaintiffs are entitled to get the entire amount of his deposit with interest which is assessed. The further case of the plaintiffs, the defendant was permanent employee of TISCO, but he took voluntary retirement from service and he's trying best to realize the entire money from telco, including the lump sum as payable for him for voluntary retirement, and trying to get the same within 2 or 3 days as he's trying to leave jurisdiction of this court. The plaintiff has stated that in the instant case that it's very difficult for the plaintiffs to get their claims from the defendant number 1. With these averments, the plaintiff has found. Now, the suit was essentially, the relief was claimed only against the plaintiff, even though averments were made against the defendant number 2 bank also. No, lords, what the defendant number 1 appeared and contested the suit. He filed a written statement. The defendant number 1 has filed a written statement stating therein that the plaintiffs have cause of action for the suit, has no cause of action for the suit and right to sue the defendant, and the suit as framed is not maintainable. Before this, it's barred by principle so and so. And thereafter, he said that, Lord, the main part is the defendant number 1 has also not denied regarding making of fixed deposit of 10,000 each in the name of plaintiffs as detailed in schedule. About the maturity date of the fixed deposit has not denied. Further, defendant number 1 has also not denied taking loan of 15,000 fixed deposit against the fixed deposit of the plaintiffs as they were in urgent need of money for starting some business. The defendant number 1 has stated that as the plaintiffs are the nephew and they were living under his guardianship, and the money was given to them for starting some business at their native village. The defendant number 1 has denied that he invested the money in his workshop at Adityapur. The defendant number 1 also alleged that the age of the plaintiffs given in the bank record is not correct. The defendant number 1 has also denied that he took the loan in collusion with the defendant number 1 has alleged that the loan from the defendant number 2 bank against the fixed taken for the plaintiffs, as the defendant number 1 had to maintain them and had to meet the expenses for the education and maintenance of the plaintiffs. It is stated that the plaintiffs have been getting money from the defendant number 1 from time to time, and were never whatever amount was withdrawn from the bank were fully spent for their welfare, maintenance and education. Besides, it is stated that the defendant number 1 gave money to the plaintiffs when they demanded, and they and their mother were getting money from time to time. Defendant number 1 has further stated that he never appropriated the money for his behalf as alleged by the plaintiffs and took the loan against the fixed deposits for the welfare and maintenance of the plaintiffs. Further, the case of the defendant number 1 is that in excess of the amount withdrawn against the fixed deposit, he has spent approximately 3,000 on different occasions. The plaintiffs and their mother, whatever they needed money as being the guardian, he never denied to fulfill their demands. As such, the defendant number 1 has claimed a sum of rupees 10,000 from the defendants amount, as a set off, and he has been still living.
What is your point of law?
Lords, my point of law is now the bank said in his separate written statement that the defendant number 1 came to the bank. He came as a natural guardian and he took the 2 FDs. He opened 2 FDs, and against he represented before the bank to be the natural guardian, and the fixed deposits were opened, and before the bank he appeared as a natural guardian and took a loan subsequently also.
When was the loan granted?
Loan was granted, Lords, sometime in 82.
Sometime in
82. They were minor because plaintiff number 1 is the elder brother. He claims to be born in 65. But there was no date of birth which was not filled by the defendant number 1. Those have come in the trial. So, my lords, my respectful submission is one, that if your lordship sees the relief portion of the plaint, then it will be given that the relief was directed against the defendant number 1. During, my lords, after the judgment, there was a attachment proceeding against the salary of the defendant number 1, which he provided some security. What happened to that security? That has not been disclosed in the judgment. So, my lords, the relief was essentially sought against the defendant number 1 only. Now, the learned trial court has granted a decree of jointly and severally against the defendant number 2 as well. Now, secondly, my lords, the bank says that here is a case that subsequently the bank comes to know that it is a case of void. It may be because Section 11 of the Hindu Minority and Guardianship Act says that after commencement of the act, the de facto guardian, because he appeared as a natural guardian before the bank. Now, it says Section 11 of the Hindu Minority Guardianship Act that after commencement of that act, any agreement by the de facto guardian with regard to the minor's interest or with regard to its property is illegal. Now, my lords, as per Section 65 of the Contract Act, which provides that if the minors have received benefit under the fixed deposits, then under the Section 65 of the Contract Act, which provides that if subsequently it comes to the knowledge that it is discovered to be a void agreement, then in that event also, if the minor has received benefit out of that, then he is entitled for restitution. Independent of this aspect, lords, the bank also says, since the defendant number 1 has misrepresented, and if at all he has misappropriated, he represented before the bank as natural guardian, so there was no fault on the part of the bank for granting of loan is concerned. So the bank granted a loan because the money came from the hands of the defendant number 1 to the bank. They say, the plaintiffs, this amount was given from a property sold at Jug Salai from the grandmother. But there is no evidence except oral.
Hardly matters.
But in the plaintiffs admit that...
Hardly matters from where the money has come. Admittedly, it was with you. Admittedly, the fixed deposit was with you, and both the courts have held that in collusion you have...
No, there is no finding of collusion. Had there been a finding of collusion, it could have been otherwise.
Yes.
It only says...
Yes.
The appellate court says that in view of Section 11, the appellate court, Lords,
yes,
the appellate court says that in view of Section 11 of Hindu Minority and Guardianship Act, since de facto guardian could not have done so, and as such, there is no legal sanctity of those loans, and such there is no right of recovery. Now, Lord, the issue is...
Come to page 25 of the inner page 11 of the trial court judgment.
It cannot be ruled out that in the...
Come to inner page 11 of the judgment, first paragraph, last fourth line. It clearly goes to show that the bank, in collusion with the defendant number 1, has done the same in violation of the rules. So it's a finding of collusion.
But Lord, as far as this aspect is concerned,
this has been upheld in the appellate court judgment. So
Lord, the appellate court judgment does not go into this issue at all. It only goes on the issue of Section 11.
Yes.
Para 22 onwards, if Lordships. Para 21 also it says about the account opening form and things like that.
Yes.
Account opening form of 532810A dated so and so, and deposit receipt shows that a special fixed deposit was opened in the name of Rakesh Chandra Sharma by Shyam Sundar Sharma, describing himself as his father. The date of birth of Rakesh Chandra Sharma was so and so. 66. The monthly interest to be credited on account of so and so. Rakesh Chandra was shown as under the guardianship of Shyam Sundar Sharma. The application was accepted and account opened. The signatures so and so and attested. And the manager of the bank, defendant number 2, similarly filled in the form of account so and so and deposit receipt. Exhibit 6/8. Exhibit 8A/1 shows that the Shyam Sundar Sharma had opened fixed deposits in the name of Rajendra Sharma, born on 3/6/68. The column of acceptance of attesting in the form is blank, but it is an admitted case of parties that the 2 accounts were opened. The column of the deposit of interest is also blank in the form, but this is also admitted by defendant number 1 that the interest under both the accounts both these forms were deposited in the account. These two FDs were to mature on completion of 63 months. Another omission is regarding the amount of money deposited in these two FDs, but it is not an admitted case that each account was opened by depositing rupees 10.
Both the courts have held that the
No, Lord, if your lordship sees
loan
the
was granted without any sanction of law.
No, Lord, my respectful submission is, firstly, Lord, the suit was essentially filed against defendant number 1. So the grant of decree jointly and severally against the defendant number 2 is also bad in law, because the amount was attached. If your lordship sees of the defendant number 1, salary was attached. That has come. And secondly, my lords, that's probably in the trial court judgment. I just if your lordship sees the appellate court judgments, it does not go into the evidence of DW1 at all. Defendant number 1, he has led 6 witnesses, and he all said that I had remitted the interest accrued from the FD in the name of the mother of the plaintiffs, and that was received by the plaintiff number 2, and money order receipts were filed. So he tried to show that this loan was taken for the benefit of the minor, and it was utilized for their maintenance and this.
So he
Because
has
I'm not advancing the case of defendant number 1.
that defendant number 1 has not challenged that.
No, Lords, I'm not advancing the case, but I am saying there is no fault on the part of the bank. As for the decree is concerned, that has been satisfied perhaps. And there was no occasion to have granted a jointly and severally decree against the defendant number 2.
If the decree is satisfied, then what remains?
Lords, because the appellate court judgment, I'm not sure, Lords, but the appellate court judgment at one place has said.
The counsel for the appellant submits that most probably the decree has been satisfied by the respondent number 1. By the original defendant number 1.
Original defendant number 1.
Defendant number 1, full stop. Considering the aforesaid submission, let notice be issued to respondent number 2 and 3 by registered and ordinary process, requisite 3 weeks.
Lords, perhaps your lordship has written that most probably.
Yes,
because
probably.
I'm not sure, because the bank does not have so much.
The counsel for the appellant submits that most probably the decree has been satisfied.
Much obliged.
By now. Yes, next.
Serial number 29, second appeal, 138 of 16. Mr. Amar Kumar Sinha, Mr. Sandeep Verma, Mr. Sumit Kumar, Mr. Kundan Kumar Ambastha for the appellant.
Yes. Who is appearing?
There is an IA habilitation of 68.
So why it is under the heading for admission? Yes, who is appearing? Who is appearing?
Melody.
Mr. Amar Sinha?
My lord, I will appear, my lord, just a moment, my lord. I will appear, my lord. Ek minute.
Mr. Verma? Mr. Verma, the case has been wrongly listed.
Okay, my lord. My lord.
The delay is yet to be condoned as no order has been passed on the application filed under Section 5 of the Limitation Act, filed by the appellant. Considering the aforesaid fact, list this case under the heading for orders next week.
My lord, deeply obliged, my lord.
Serial number 30, second appeal 151 of 16. Mr. Ashraful Zaman Khan for the appellant.
Since your lordship, since the concern was Mr. M.A. Khan has been passed away, my lord, I have to file Vakalatnama. I have received the same, my lord, and I will file.
It has been informed that Advocate Muhammad M.A. Khan.
Yes, my lord.
Advocate M.A. Khan has expired. Full stop. Next para. Mr. Anis Khan, appearing, submits that he has received instruction and he will appear in this case on behalf of the appellant. Full stop. He prays for some time. Prayer allowed. List this case after 4 weeks.
Yes. Deeply obliged, my lord.
Serial 31, second appeal 159 of 16. Mr. Kaushik Sarkel, Mr. Abhishek Piyush for the appellant.
Yes, my lord, I am appearing in this case.
Yes.
My lord, the present appellants were the defendant in the suit which has been filed for partition, my lord.
Yes.
If lordship may kindly come to the trial court judgment for a while, and thereafter also the appellate court judgment. The appellate court has not exercised his power under Order 41, Rule 33.
Yes.
Lordship may kindly see the relevant portions of the trial court judgment start from paragraph 2, my lord.
Yes.
Prior to that, the prayers are there. May I read from paragraph 2 onwards?
Yes. Yes, read it.
The case of the plaintiff as appearing from the body of the plaintiff is that, para 2 I am reading, my lord.
Yes.
The case of the plaintiff as appearing from the body of the plaintiff is that the parties are Hindus and are governed by Dayavaga School of Hindu Law. The lands described in the schedule of the plaintiff have been recorded in the name of Bhuvan Ghosh, son of Gopinath Ghosh during the last survey settlement. Following genealogy table given by the plaintiff in the plaint shows the relationship of parties with the recorded tenant, my lord. Recorded tenants have 7 sons, my lord.
Yes.
And this plaintiff is from the line of, my lord, one of Govindo, my lord.
Yes.
And we are from this Bhagirath. It has wrongly been stated that defendant number 1 is Sital. I am the son of Sital but adopted son of Bhagirath. The recorded tenant Bhuvan Ghosh died in the year 1960, leaving behind his only son Govindo Ghosh. And his other 6 sons have predeceased their father. Out of the said 7 sons, Bhuvan Ghosh, namely Mohidar Ghosh, Magan Ghosh, Surji Ghosh, Bhagirath Ghosh, Jamuna Ghosh died issueless. Hence, their interest of their property devolved upon Govindo Ghosh. Said Govindo Ghosh also died in the year 1962, leaving behind only daughter Rangawala Dasi, and the plaintiff are the sons of Rangawala Dasi who are married at village Velua with Jogindo Mandal. The defendants are the grandsons of Sital Ghosh, and the defendant number 1 is living in Bekrakuri, whereas defendant number 2 and defendant number 3 residing in West Bengal. The plaintiffs are rightful owners of the lands of Bhuvan Ghosh and they are peacefully possessing the said lands. The defendants are also the co-share of the plaintiffs and they have got equal share of the lands of Bhuvan Ghosh, and the plaintiff and the defendant used to possess the land jointly without making any partition by metes and bounds. It is further stated that last year the plaintiff have cultivated the land and grown paddy crops over this side land of Govindo Ghosh, but the defendant number 1 did not allow the plaintiff for harvesting of the paddy crop, for which there was a serious apprehension of breach of peace, and hence plaintiff has filed a case under 145 CRPC. With respect to the suit land, which is registered as criminal miscase such and such, and the said petition under 145 is referred to the police. And thereafter, if Lordship may kindly see the case of the defendants, my lord, that in the instant case, defendant have to in the written statement and submitted that 7 except what has been specifically admitted in the written statement, defendant denied the other statement made in the plaint and put plaintiff to strict proof of their. The suit is not maintained either in law or in facts. The plaintiffs have got no right, title, and interest and share in the suit land, and further are not in joint title or possession of the suit land. Plaintiff have got no cause of action of the suit. The defendant number 1 is the adopted son of Bhagirath Ghosh, who has been duly adopted and recorded in the registered adoption deed. The statement made in para 1 of the plaint is partly correct and partly incorrect. It is admitted that parties are Hindu but are not governed by Dayavaga school of Hindu law. They are governed by Mitaskara school of Hindu law. The statement made in para 2 of the plaint is admitted. The relationship given in para 3 is admitted with a clarification that Santosh Ghosh has been transferred to the family of Bhagirath on his adoption. The date of, this is very important, the death of Bhuvan Ghosh as mentioned in the plaint is false and denied. Bhuvan Ghosh died in the year 1953, not in the year 1960. And he died leaving his 5 sons, that is Sitol Ghosh, Maninder Ghosh, Magan Ghosh, Jamuna Ghosh, and Bhagirath Ghosh. And other 2 sons, Govinda Ghosh and Sorju Ghosh, predeceased his father, Bhuvan Ghosh. This is the main dispute, my lord. The adopted son of Bhagirath Ghosh has not been shown in the genealogy in the proper place. The statement made in para 4 and 5 of the plaint are not at all correct, and as such, the same is denied by the defendant. Bhuvan Ghosh died in the year 1953, not in the year 1960. It is stated that it is false to state that Bhuvan Ghosh died leaving only his son Govinda Ghosh, and the other sons predeceased their father and died in the year 1949. Similarly, Sujo Ghosh, who predeceased his father, the other sons, that is Sital, Maninder, Magan, Bhagirath, Jamuna, survived their father. And Maninder and Magan died in 1955, Sital in the year 1964, and Bhagirath in the year 1982. It is also false to state that the interest of Mahinder Ghosh, Magan Ghosh, Surji Ghosh, Bhagirath Ghosh, Jamuna Ghosh devolved upon the Govinda Ghosh. It's already submitted that Govinda Ghosh predeceased his father, and there is no question of devolving the interest upon Govinda Ghosh. The statement made in para 6 of the plaint are wrong and false. As such, the same is denied. Govinda Ghosh died in the year 1949, not in the year 1962. Govinda Ghosh did not inherit and succeed the property of a father as he predeceased his father. The statement made in para 7 of the plaint are correct and admitted, and the statement made in para 8 and 9 are not being correct and denied by the defendant. The defendants are not the co-sharer with the plaintiffs, and the plaintiffs have no share in the suit property and are not in joint possession of the plaintiffs. The plaintiffs are not the rightful owners of the lands of Bhuvan Ghosh and are not in possession of the suit land and never possessed the suit land. And reply to made in para 10 of the plaint, it is submitted there was a proceeding under CRPC and that the proceeding has been dropped. The proceeding was initiated on wrong and false assertion. It is false to state that the last year the plaintiff cultivated the land and have grown paddy crops. The defendants are as usual every year, including last year, cultivated the lands, grown paddy crops and harvested the same, and the lands all along has been coming in their exclusive possession. It is also stated the statement in para 8 based on an imagination and concocted one and has been invented for the purpose of the suit. The assertion of panchayati request for partition etc. are all false, and there is no such request, and further there is no scope and cause of action for the suit. It is further stated in para 12 of the plaint is wrong. The plaintiff has got no share for the less half in the suit property and are not entitled to any share. It is further submitted that the court has no jurisdiction as the valuation of the suit is much less than 500, and Bastu has wrongly been valued at 1,000, which should be valued as 10 only. And the value of such called injunction is arbitrary, and the statement made in para 13 are wrong. It is further stated that statement made in para 14 of the plaint that the suit properties are neither joint nor in joint possession. As such, the suit is fixed. Court fee is not maintainable. Submitted the statement made in para 15 of the plaint that no title and share or possession in the suit land, and there is no need or scope of injunction as the suit land are in peaceful and legal possession of the defendant on payment of rent. The plaintiffs are not entitled to any relief. And thereafter, one more defendant has filed a written statement that is in para 6 that has been discussed, my lord. Now, on the basis of this, my lord, he also stated the same thing that has been stated by us, my lord, in this written statement. The following in para 7, my lord, the following issues were framed, my lord. Now, out of all these issues, one issue has been decided in favor of the defendant. That is issue number 4, that Santosh Ghosh is the adopted son of Bhagirath Ghosh. And other issues has been decided in the favor of the plaintiff, my lord. I'm only saying, my lord, that the learned trial court has not even discussed the witnesses and has given a perverse finding on the issues, my lord. And that will be apparent from the finding of the trial court itself, my lord. If my lord may kindly come to the issues, first issue, that is para 12 of the judgment of the trial court, my lord.
Yes.
From assertion of both sides, it is apparent that the most vital issue in this case, that whether the recorded tenant died in the year 1960 as claimed by the plaintiff, or in the year 1953 as has been stated by the defendant. So this issue is the most important one, and this issue has been recasted for discussion and determination in this case. And another important issue is whether the parties are governed by Dayavaga School of Hindu law. So I take up the issue 5 first for the discussion and determination. Plaintiff have pleaded that they are governed by Dayavaga School of Hindu law, whereas it has been alleged by the defendant they are not guided by Dayavaga School of Hindu law in the matter of inheritance and succession. It has been submitted by learned counsel for the defendant. Dayavaga School is relevant in Bengal, whereas in the parts of the country, Mitaskara School of Hindu law is relevant in the matter of inheritance and succession. The evidence available on record gives an inference that parties are guided by Dayavaga School of Hindu law, as most of the plaintiffs has given evidence on this point, and it has been stated by the
Yes.
Plaintiff himself has stated in para 29 of the cross-examination that they are Pallav Gwala, and the evidence that the School of Hindu law. No positive evidence on this point has been given by the defendant. So on this basis, the custom relevant in the society of the parties, I find that the parties of this case are governed by Dayavaga School of Hindu law, and accordingly this issue is decided in the favor of the plaintiff. Now the next, my lord, whether the recorded tenant Bhuvan Ghosh has died in 1960 or in 1953. It has been pleaded by the plaintiff that recorded tenant Bhuvan Ghosh died in the year 1960, whereas defendant has claimed that the recorded tenant of the suit property Bhuvan Ghosh died in 1953. It appears that both parties are making contrary claim about the year of death of the recorded tenant Bhuvan Ghosh in view of coming up in force of the Hindu Succession Act 1956. Prior to Hindu Succession Act 1956, in Dayavaga School of Hindu law, as well as Banaras, Mithila and Madras School of Hindu law, the property inherited by a woman, whether from a male or a female, does not become her Strigan. She takes only a limited interest in the property, and on her.
Yes.
Yes, sorry, my lord, I got disconnected.
Yes.
Now, Lordship, kindly see the finding. He has not discussed this. The trial court has not discussed that what witness has stated about the date of death, my lord. Only with regard to one PW, that is PW1, who is aged about 40 years in the year of 2008, and has stated that he has not seen Bhuvan Ghosh and also his son, and who has died prior to his birth. Since the plaintiff in the year 2008 was aged about 40 years, so it means that he took birth in the year 1968, and he stated that Bhuvan Ghosh and his sons died before his death. So this statement of this witness gives an inference that the recorded tenant may have died in the year 1960. PW2 is the plaintiff of this case. He has stated in cross-examination also that Bhuvan Ghosh died in the year 1960. PW3 has also
LCR is
stated
here. LCR is here.
no, my lord, LCR is not there.
Issue notice to how many respondents? Issue notice to respondent number 1 to 4, registered ordinary 4 weeks. Should call for the NCR. List this case under the same heading.
All right.
Serial number 32, second appeal 204 of 16, Mr. Prashant Pallav, Mr. Mantu Kumar Sinha for the appellant.
My lord, I am just praying for a day's accommodation, my lord.
Right.
My lord, I was praying for 1 day's accommodation, my lord.
Next week,
Yes, my lord.
on the request of the Learned Counsel for the appellant, list this case next week under the same heading.
Grateful, my lord.
Serial number 34, second appeal 238 of 16, Mr. Arun Kumar Ray, Mr. Sudhir Kumar Sharma, Mr. Avnish Shankar for the appellant.
Yes, my lord. I am appearing, my lord, for the appellant.
Yes.
My lord, the appellant was a plaintiff, my lord. And suit was, my lord, filed, my lord, for a declaration that, my lord, the diff number 1, my lord, is not the adopted son of Mosmat Hakni Darbain.
Okay.
And also, my lord, for declaration that the adoption deed, my lord, that was executed, my lord, on 8/8/1970, my lord, by the Hakli Darbain, Mosmat Hakli Darbain, in favor of defendant number 1, is not, my lord, is ab initio is void, my lord, and unlawful, and is not binding on the plaintiff, and also for the cancellation of the said deed. This was the prayer, your lordship, by the plaintiff. My lord, there were 4 brothers, your lordship. One was, my lord, Guru Charan Darbe, another was Janadi Darbe, and Angaraj Darbe, and Hardeali Darbe. My lord, the Hardeali Darbe, my lord, died issueless, and his widow is Mosmat Hakli Darbain, my lord. And so far as the plaintiffs and the defendants and the other performer defendants, your lordship, are concerned, they are the, my lord, the descendants of Janardi Darbe and Angraj Darbe. My lord, the natural father of the defendant number 1, my lord, Ramjivan Singh, my lord, he has been implicated as a party. My lord, the learned trial court, your lordship, concluded, my lord, that, my lord, deed is, my lord, valid, and, my lord, subsequent to, my lord, the execution of the deed.
You say that the deed is not valid?
No, my lord, the learned trial, both the courts said, my lord, that the deed is valid.
So you are challenging that, same. What is your ground?
Yes, my lord, I'm challenging. Yes, one more thing I want to say, my lord, that, my lord, after the execution of the deed, my lord, on 8/8/1970, my lord, within the 3 months, my lord, the Mosmat Hakli Darbain, my lord, they cancelled the adoption deed by virtue of, my lord, the registered deed. That is also on record. That is 8/8, my lord, 8/11/2000, my lord, 17. My lord,
what is the effect of that?
Yes, I'm coming to that. My lord, it is not in dispute, my lord, that both the deeds are registered deeds. That is also an adoption deed, is also a registered deed, my lord. And as per the section, my lord, 16, my lord, there is a presumption attached to, my lord, the deed of adoption. This is the law. That proposition of law, I agree.
Deed of adoption is dated?
It is dated, my lord, 8/8/1970.
8/8/1970.
70, my lord.
When did you file the suit?
My lord, suit has been filed in the year 2006.
So is it not barred, hopelessly barred by limitation?
Yes, my lord. That aspect has been also, my lord, dealt by both the courts, my lord. Court below has said, my lord.
Then
My lord, it is barred.
If it is hopelessly barred by limitation, why should I enter into the other grounds?
But your lordship may kindly appreciate. Yes, may kindly appreciate.
If a suit is hopelessly barred by limitation, is it necessary to go into the other aspects?
But yes, my lord, one point your lordship is relevant. Unless and until, my lord, the deed is itself valid in law. If the deed is valid in law, my lord, I have nothing to say.
No. You are praying.
My lord, my contention, your lordship.
You are praying for a declaration.
I am praying for a declaration.
You are praying for a declaration for cancellation of a deed, taking it to be invalid, telling it to be invalid.
That is one of the prayer, your lordship.
The suit by itself is barred by limitation.
My lord, may kindly appreciate that, my lord, the main prayer, your lordship, is for a declaration that, my lord, the defendant number 1 is not the adopted son of the, my lord, the Hagli Darbain. And, my lord, as per us,
your main prayer is cancel the sale, cancel the adoption deed.
Your lordship, may kindly see the prayers, my lord.
There is a registered adoption deed.
May kindly see paragraph 2 of the appellate court judgment.
Just tell me you have prayed to cancel the registered adoption deed, yes or no?
Yes, my lord, I have said, I agree. Yes, I agree, my lord. That is one of the prayer. But, my lord,
what is the
period your lordship is 3 years, my lord, as per the section 59 of the law.
You have filed more than after 33 years.
But your lordship may kindly appreciate that, my lord, the cause of action, my lord, arose to us in the year 2006, my lord.
How?
Because, my lord, our contention, your lordship, is that, my lord, the Jagjivan Ram, who is the natural father of the defendant number 1, your lordship, he was a village pradhan, and, my lord, he prudently, my lord, got registered, my lord, this deed, and which was not the intention of the Mosmat, my lord, as because within 3 months of the execution of the registered deed, she cancelled it.
No.
And, my lord, being a village pradhan, my lord, he managed to, my lord, get the rent receipts, etc. also.
What is
and actually, we were also in the possession, my lord. We were also in the possession.
What is the concept of limitation? Mr. Sharma, is it not that the limitation extinguishes your right to sue, even if you have a right to the property?
My lord, it's barred remedy, my lord. It does not extinguish my right.
Yes.
That is my humble
remedy is barred.
Section 29 says.
Your
Yes,
right to sue is barred. Your right to sue is barred. Your right to file a suit for
remedy. I do agree.
Remedy is barred.
Remedy.
So you have a very good case, but your remedy is barred. You have nothing.
But your lordship may kindly appreciate.
There's nothing.
Had it been a, my lord, registered deed, my lord, and had it been a valid deed, my lord.
No, whether it is a deed or valid,
as per the law, then the question of limitation come into play.
No, who says so? Who says so?
My lord, there are judgments to that effect. If something is
just tell me your ground for cancellation, whatever may be your ground. You may have a very good ground, but your remedy is not there by virtue of the limitation. Look here, heard the counsel.
To that, my lord, I very humbly want to submit, my lord.
Yes.
That, my lord, if something is ab initio word, my lord, then, my lord, the question of limitation will not come into picture.
How are you saying that it is
There are
evidential?
judgments to that effect. I may show it. to you.
It's a registered deed. The presumption is in favor of the
Yes.
deed. You have to disprove.
Yes, but your Lordship, I kindly appreciate the cancellation deed is also a registered one. And your Lordship may kindly appreciate section 11 says,
How
how
can a registered document be cancelled?
That is the question. That is the question. I am definitely, my lord. I want to answer it.
Yes.
But your Lordship may kindly
Answer first. How can a registered
this is at least, my lord, an attending circumstance, my lord.
How can a registered deed be cancelled? How can a registered document be cancelled? Like a
under section 31, under section 31 of the, my lord, the specific relief act, by filing a suit. By filing a suit, my lord, I agree to this proposition.
A suit was not filed. So that cancellation is bad. So that cancellation deed is expressly bad against the law.
My lord, there are judgments to that effect also, my lord, that there is no such provision, my lord, in the Registration Act, my lord. So far, provision is only with regard to registration.
What is the law? I'm asking you, what is the law?
My lord, the law is, your Lordship, is that a cancellation deed can be registered. But whether the original deed can be cancelled by way of a registered deed or not, that is an issue, my lord. I agree, my lord. I agree, my lord, that section, it will be governed by the section 31 of the specific rule.
Yes.
I'm not on that. I'm not on that. What I want to contend before your Lordship is that, my lord, if a person, my lord, who executes a deed, a registered deed, even if a registered deed, my lord, subsequently within period of 3 months, my lord, if the deed is cancelled, then, my lord, it is an attending circumstance.
That cancellation can be taken in cognizance, which is not as per the law.
My lord, it is an attending circumstance, my lord. There are judgments to that effect that the defendant has to dispel the attending circumstance.
That you had to prove in the suit. The attending circumstances you have to bring in as an evidence in that suit. When the suit
I have brought it, my lord. I have brought in record.
When the suit itself is barred by limitation, then?
Yes, that point, your Lordship, to that my very respectful submission, your Lordship, is that, my lord, so far as this suit is concerned, my lord, it is the only prayer, had it been only prayer for cancellation of deed, my lord, then, my lord, I would not have said anything.
No, your main.
But, my lord, there are
just tell me one thing. Without cancelling the sale deed, could it have been held that he is not adopted? The adoption is bad.
Yeah, my lord, the court could have held, my lord, that the deed is not valid in law.
That adoption is bad and the deed is valid.
No, I said the. My lord, so far as the adoption, your Lordship, is concerned, my lord, it will be governed by section 11.
Mr. Counsel,
my lord,
your prayer is for declaration of the deed, cancellation of the deed on the ground that the adoption is bad.
Yes.
Your prayer is cancel the deed.
It's not a valid deed.
You cancel the deed
not valid
and the adoption is bad. Now,
yes.
Now your prayer is to cancel the deed.
It is a consequential prayer, as per me.
Main
prayer, your Lordship, is for main prayer.
It is a consequential prayer.
Right.
It is a consequential prayer. The adoption deed is registered.
Yes.
So what is the presumption?
But your Lordship, I would like to show section 16 of the Hindu Maintenance and Adoption Act.
Yes.
Your Lordship, may kindly.
Yes. Come to that.
First, I would like to show, my lord, section 11.
Yes.
What are the valid, my lord, the conditions for a valid adoption? I am on 6, my lord. 11.6, my lord.
Yes.
the child to be adopted must be actually given and taken in adoption by the parents or the guardian consent or under their authority with an intent to transfer the child from the family of its birth, or in the case of an abandoned child or a child whose parentage.
Now answer my second question.
Mal.
So Mr. Sharma, answer my second question. Even if there is no deed, even if there is no
Mal.
deed, an adoption has taken place. An adoption has taken place. What is the limitation to challenge that adoption? What is a suit? If you challenge a particular cause of action in a suit, and if you want to declare a particular transaction void in a suit, what is the maximum limitation? It cannot be for an indefinite period.
Malad, I agree, Malad. That Malad, the limitation is Malad 3 years. If to, for cancellation, for cancellation, it is 3 years.
For cancellation of a deed, suppose there is no deed. Suppose there is no deed.
No, but there is no deed, Malad.
Then what is the limitation?
Then Malad, the cause of action. If suppose your lordship, I am aware regarding something that it is Malad, it is affecting me, Malad, then Malad, it will be governed by the cause of action.
From the date of cause of action.
Yes, Malad. If I can prove.
What is your cause of action for cancelling for praying for cancelling the adoption?
Yes.
What is your cause of action? Once he has been adopted. Once he has been adopted.
My cause of action.
Once he has been adopted illegally, your cause of action, your time starts from then.
The cause of action, your lordship, is I have the copy of the plaint with me, Malad.
Yes, cause of action is.
Yes.
Your cause of action is.
Malad, I am reading it. Malad, the cause of action for this suit, Malad, I am reading para 25 of the plaint, Malad, arose on 30th of November 2006, Malad, when the defendant first party, Malad,
when the first
party, along with few persons, wanted to harvest the grown paddy crops of the plaintiff in the plot lands of the deceased recorded tenant of Mosmat Hakli Darmain, wife of late Agnihori Dabe, on the basis of the false and illegal and inadmissible deed of the adoption. Was executed and registered at Dumka sub-registry.
Is it your case that Mr. Sharma, is it your case that for the first time in 2006 you came to know about that adoption?
Well, the case is so pleaded.
No, tell me.
Case is so pleaded.
Have you pleaded that? Is it your case that only in the year 2006 you came to know about this deed of adoption?
Malad, so far as the documentary evidence are concerned, Malad, and the learned courts below have considered it, Malad. There were, Malad, certain 144, 145 proceedings, Malad. That is on record. That I cannot deny.
So it is not your case that in the year 2006 you came to know about the deed. This deed came to your knowledge when in the year.
Malad, may allow me, Malad, to say, Malad, something.
Yes.
Malad, my contention, your lordship. Despite Malad 144, 145 proceedings, your lordship, and Malad remand by the Malad district court, Malad, to the subdivisional officer, Malad, and as because there was a cancellation deed, Malad, already on record, Malad, and so Malad, the parties were, Malad, despite these litigations, were in the position, your lordship. One, Malad, when they came, Malad, and they started, Malad, interfering with the part of the Malad, the land where we were in position, and that too in the year 2006, Malad, when during the harvest, Malad. Thereafter, the Malad, the suit was filed. And had there been no cancellation deed, Malad, naturally, Malad, there was no occasion.
What is the effect of that cancellation deed? It is
yes.
It is void in
effect of the cancellation.
It is void in the
effect of. Malad, so far as the deed itself is concerned, Malad, so far as deed itself is concerned, Malad, it is a registered one, and Malad, it is at best, Malad, the court could have, Malad, considered it as an attending circumstances.
No.
Your Lordship may kindly appreciate. If there is any allegation of fraud, is any allegation like that, my lord, then my lord, the defendant is to dispel the, my lord, this attending circumstances. There is a registered deed of cancellation on record.
Don't put the cart in front of the horse. It is your case for cancellation of a sale deed. You have to prove that that cancellation deed can be an attending circumstances for you to in your main prayer of cancellation of a deed.
No, I have said so, my lord. A specific prayer is there.
But whether the law allowed you to file this suit for cancellation of the deeds after 33 years? Tell me. Answer this question to me. Does the law allow you to file a case for cancellation?
I have already, to that effect, I have already replied. The main prayer, your lordship, was main prayer, your lordship, is for a declaration that, my lord, the defendant number 1 is not the adopted son.
Yes. So
if had there been,
see, what is the limitation period of a declaratory suit? 100 years, 200 years, 500 years.
It will depend upon the cause. It will depend upon the cause of action.
So what is the cause of action?
Cause of action is my lord,
for declaring an adoption void. For declaring an adoption void, what is the cause of action? And it is also not your case that you came to know about the adoption in 2006. Come to
I have very specifically pleaded. We have very specifically pleaded, my lord, that despite, my lord, litigations, 144, 145, my lord, even, my lord, after the remand, the position was declared in the favor of defendant. My lord,
it is your case is not for right title in interest and position. Your case is not for right title, interest and position. Then your prayer is not. In fact, I am only arguing. Your prayer is not for right title, interest and recovery of position or confirmation of position.
No.
Then
two things are very relevant, your lordship. I kindly appreciate. Any deed of adoption, my lord, if any of the conditions has not been fulfilled, my lord, then, my lord, there cannot be any validity to the adoption, even if, my lord, it is by
Mr. Sharma,
it is even if it is by
Mr. Sharma, there has to be a declaration by the suit, and the law grants you how much you have to file that suit. Tell me.
But I very humbly say, my lord, it depends upon the cause of action. In the 2006, my lord.
Mr. Sharma, please, I have given you enough time. Please don't waste time of this court. Heard the counsel for the appellant. Full stop. In this second appeal, the appellant has preferred. This second appeal is preferred against the concurrent judgments passed by Senior Civil Judge 1 Dumka in title suit number 102 of 2007, whereby the suit was dismissed, and against which the appeal preferred by the appellant herein in title appeal number 10 of 2013 has also affirmed the judgment passed by the trial court. Full stop. Next paragraph. Against the concurrent judge finding of facts, this appeal is being filed by the appellants. Full stop. Next paragraph. The appellant's plaintiff preferred the suit being title suit number 102 of 2007, praying therein to set praying therein for a declaration that the adoption of
it is para 2 of the appellate.
Yes. Adoption of what is the name of that child?
Child is Malad. It was earlier it was Dara Singh, but Malad he claims Malad after adoption it is Brahmdev Singh.
Dara Singh alias Brahmdev Singh as void. They also pray to declare the adoption registered adoption deed dated 8th May 8th May 1970, registered adoption deed bearing number 690 dated 8th May 1970 to be null, void and inoperative and was never acted upon. Full stop. Next para. It is the case of the plaintiff, appellant, that by way of fraud, this adoption deed was executed and none of the conditions of the laid down under section 11 of the Hindu Adoption and Maintenance Act of 1956 has been followed. They state it is further case of the plaintiff that 3 months after the execution of the same registered deed, comma, the Musammad Akali Darbai executed another registered deed and cancelled the earlier deed of adoption. It is submitted that the aforesaid fact clearly suggests that there was no intention to adopt, and thus the earlier adoption deed, which was executed on 8/8/1970, is absolutely bad and should be and has got no effect and has no effect and should be cancelled. Full stop. Both the trial court and the appellate court concurrently held that the registered deed which was executed in the year which was executed on 8/8/1970 is valid, and the plaintiffs have failed to prove that the cancellation of the cancellation deed by which the adoption was cancelled is not legal and valid. Full stop. Next one. It is, after hearing the parties, I find it is further it is clear that an registered deed cannot be nullified by merely executing another registered deed. The law is well settled in this respect. Full stop. As per the Hindu Adoption and Maintenance Act, in terms of section 16, there is a presumption of validity of a registered document, a registered adoption deed. Full stop. Both the courts have found that the deed to be valid. Full stop. Further, another aspect cannot be lost sight of is that a deed of adoption dated 8/8/1970 is sought to be cancelled by filing a suit only in the year 2007. Full stop. That means after how many years?
Yeah, more than 33 years.
The suit has been filed more than 33 years from the date of adoption and execution of the deed. Full stop. What is the limitation? Let us see.
Section 59, 3 years.
Section 59.
Article 59.
Article 59.
Of the Article 59.
Part 3 of schedule write like this. Article 56 to 60 of the Limitation Act deals with the suits in relation to declaration. Full stop. The Article 57 deals with a suit in which relates to obtaining a declaration that an alleged adoption deed is invalid or never in fact took place. Full stop. The period of limitation alleged adoption becomes known to the plaintiff. Full stop. In this case, it is not the case of the plaintiff. It is not the. It is admittedly not the case of the plaintiff that they had knowledge. They got knowledge about the said adoption deed just 3 years prior to filing of the suit. Rather, it is the case of the plaintiffs that they knew about this suit much before that, as there were litigation between the parties in the year 1987, 86 also. Full stop. This clearly suggests that the suit the reliefs which they are claiming by filing the suit is hopelessly barred by limitation also. So thus, I find no merit in this second appeal. This appeal stands dismissed.
May I say, Malad?
Yes.
Malad, one matter, Malad, 34. I want Malad honestly. No, Malad. Last.
This is 34.
No, 34, not 34, Malad.
Then
it is last but first, Malad. It is 39.
39. Adjourned.
Yes. Next week.
On the prayer for Mr. Sharma after 1 week. Yes. Next.
Serial 36, second appeal 251 of 16. Mr. Bhaiya Vishwajit Kumar, Mr. Sachin Mahato. For the appellant.
Yes, I am appearing in this case, Malad, for the appellant. The concurrent judgment, Malad. The case is like this. The plaintiff, we are the defendant, Malad, in this suit. The plaintiff has filed the suit for declaration of right title and interest over the suit property, Malad.
Yes.
And for declaration that the sale deed number such and such dated 2/3/1979, which is in the name of defendant, is null, void, inoperative, mere paper transaction, void ab initio to the extent Schedule A land, and not plaintiff are not bound by the same.
Yes.
भैया विश्वजीत जी अनम्यूट कर लीजिए आप.
Sorry, Malad.
Yes.
So suit was filed for setting aside the instrument, my lord, of the year 1979 in the year 2003, and also for recovery of possession.
Yes. There's some connectivity issue from side of Mr.
In their case, my lord, case of the plaintiff, the suit land was originally belonged to one Bhulni Hajamin, who transferred it in favor of Makru Hajam, who is his son-in-law, and Makru Hajam has sold some of the property of the scheduled land in favor of Indru Shah,
okay,
the ancestor of these defendants.
Okay.
And it is their case that the earlier suit which is said to have been filed in the year 1963 by Makru Hajam is by fraud. It was not actually filed by him, rather it is filed by the defendant's party, and which was withdrawn later on. Further, their case that in the Panchayati, the consideration amount was not given to the said Makru Hajam. On the basis of this suit has been filed, my lord. Defendant is appeared, filed written statement is stating that since the time of Indru Hajam, it is in possession of him, and in the year 1963 there was a dispute with respect to the scheduled land, and a suit was filed and it was withdrawn. And the consideration amount in a village panchayati was given to Makru Hajam. And it is further case, my lord, that in the year 1979, by virtue of registered sale deed, it was sold in favor of the defendant, and defendant got their name mutated in continuing in possession since the time, and rent receipt is being issued. The defendants have filed and exhibited several documents, including the rent receipts, the sale deed, but that were not taken into consideration by both the courts below, my lord. If my lord will look into the trial court's judgment, the document at page 28 of the brief.
Yes.
At page 28 of the brief, my lord, in para 5, second para, the plaintiff has filed only two documents, that is Exhibit 1, which is certified copy of sale deed of the year 1970, and Exhibit 1/1 certified copy of sale deed of the year 1954. On the other hand, it is the defendant who have filed the documents which is in the last para, my lord. The following documents have been filed on behalf of the defendant to support their case. Exhibit A is the order of withdrawal of title suit number 311 of 63. Exhibit B is award of punches dated 5/11/63. Exhibit B is award of the punches dated 4/10/63. Exhibit C with objection is agreement dated 6/11/63, in which executant is Indru Mahato and executee is Sri Syam Lal Sahu. Exhibit D is certified copy of the sale deed number such and such of the year 1954. Exhibit D1 is also a certified copy of sale deed number such and such dated 22/9/70. Exhibit D2 is sale deed number etna dated 6/4/88. Exhibit D is the sale deed number 1783 dated 12/2/1979. Exhibit E is certified copy of the order of the case number such and such of SDO. Exhibit F to F8 are 9 rent receipts in the name of Indru Sahu, Ugni Devi and Jhumni Devi. So our case is, my lord, that for setting aside a sale deed, the limitation is only 3 years. My lord has already taken cognizance of this fact, my lord, in the earlier case. But the learned trial judge has not discussed all these. Both the courts have not discussed all these, my lord.
Have you taken this ground of limitation?
Yes, my lord. In the written statement, we have stated, my lord, that the suit is hopelessly time barred.
How?
In para 3 of the written statement, it is stated that suit is barred by law of limitation and adverse possession. So even though,
So your claim is for adverse possession.
yes, my lord, and for adverse possession, it is not discussed anywhere regarding my possession, my lord. Although there is documentary evidence to suggest that I am in possession, and that is the rent receipt which are being issued, and their admission is that no rent receipt.
The fact that this deed was executed in the year 79 came to the knowledge of the other side only in the year 2003.
No, it is not. They have not uttered a word. Not uttered a word in their depositions. They were examined, my lord, as PW3.
Issue number three has been answered like that.
Yes, my lord. But they have not uttered a word regarding their knowledge of the document of the year 79 in 2003. It is their evidences, my lord, PW 3, 4, and 5. They are the plaintiffs. I may be allowed to read out their evidences. मैं विनोद ठाकुर, मैं मुद्दे मुदाले तकरारी जमीन को जानता हूँ। यह तकरारी प्लॉट 1249 एवं 1075 मकरू हजाम की खरीदी जमीन है। मकरू हजाम मुद्दई खेदन हजाम के पिता थे। मकरू हजाम सन 38 से इस तकरारी जमीन को खरीदे और उसी समय से दखलकार चले आते हैं। यह कि मकरू हजाम के मरने पर उनके वारिसान दखलकार हुए। यह कि मकरू हजाम को रुपए की आवश्यकता हुई। 1954 में दोनों प्लॉट के कुछ जमीन बेच दिए, बाकी जमीन पर उनका दखल रहा और अभी तक वारिसान को है। प्लॉट 1075 में 36 डिसमिल और 89 डिसमिल में इंदर साव के नाम से बिक्री किया।
What is your point of law?
So the point of law that I have formulated in my memo of appeal laws, D.
Yes.
Whether a declaration of sale deed dated 2779 null and void, and for its setting aside the limitation is provided under Article 59 of Limitation Act is only 3 years, and without meeting the point of limitation, learned court below have committed grave error of law in finding it contrary to law and without jurisdiction, especially in view of the order of mutation and grant of rent receipt exhibit E series. Then, my lord, the Court of Appeal below has wrongly decided issue number 3 in favor of plaintiff regarding knowledge of sale deed of 79 in the year 2003, especially when plaintiff, that is PW3, 4, have not uttered a word in their entire evidence, and thereby pleading is not supported by any evidence. Therefore, the finding of issue number 3 is perverse. Then, my lord, G, where the element of fraud and misrepresentation is to be specifically pleaded and pleaded with specificity, particularly and precise, and supported by evidence as required under Order 6, Rule 4. The plaintiff having failed to adduce any evidence in support of the allegation, the court have committed a serious error of law, raising the question. So these are the points of law, my lord, that I have raised. In the pleading, they have stated regarding 63 suits. In the pleading, it is stated in para 10 of the plaint, my lord,
Yes.
that on one hand, the present defendant admitted from the fact that the land originally that Harku Hajam has not filed any title suit in the year 1963 and withdrawn by him. If he had filed title suit in the year 63, then how again sold the same in the year 70 in favor of Indru Saw? The Indru Saw not disclosed the fact of title suit of 63 filed by alleged Makru Saw the suit was must be filed by Indru Saw in the name of Makru Hassan. So it is allegation against Indru Saw that it was filed by him, but this is not proved by any evidence. They have not uttered a word in their plea evidence. So fraud is to be specifically pleaded and proved by cogent evidence. And having been failed, the suit is fit to be dismissed. And my lord, there is one judgment in my hand, my lord.
Yes.
It is reported in 2019 Supreme Court Civil Reports 959.
SCC, SCC, parallel version.
It is not with me, my lord. With the name of party is Krishna Murthy S.
You just send it on mail.
I may be allowed to read out the.
Send it on mail.
Actually, my lord, only through this mobile I used to.
Later on, you send it to mail.
Yes, my lord, I will. It says, my lord, even plea of acquisition of title by adverse possession can be taken by the plaintiff under Article 65 of the Limitation Act. Here is the case. Here is our case of adverse possession who are defendants. So it is held, my lord, in our considered view, the High Court has not given cogent reason for coming to the conclusion that case was not in possession of the property. His name figured in the revenue record from 63 to 81 as owner in possession. So the case of mine, my lord, that our name is appearing in the revenue record in possession of the property. Therefore, my lord, this appeal is fit to be admitted on the substantial questions of law that I have formulated, my lord. And the lower appellate court has not discussed anything regarding the rent receipts or the documents which we have filed, my lord. And without framing any point for determination, has simply reproduced the judgment of the trial court, my lord.
No. The court has independently assessed.
Yes, my lord.
Going through the evidence. That is there.
Yeah.
Who was Indru Saw?
Induru Saw, my lord.
Husband of defendant number 1.
Yes, my lord.
That is all.
My lord.
Order reserved.
My lord, it is fit case to be admitted, my lord.
Let's see.
I will supply the judgments, my lord.
Supply the judgment.
All right.
Yes, rest at 2:15.
Okay.